Alchemist, sweeten contents to milk.
You have 4 minutes.
Thank
Sri,
you.
4 minutes.
Thank you, sir.
Sri Vaiko, please complete. Please. Sri Vaiko, please.
Let him stop.
Please. You will start.
Let him
start.
See, I have to speak.
Yes, you will speak. Your time starts now, Mr. Vaiko. Mr. Vaiko, your time starts now. Please.
Honorable Deputy Chairman, sir, I rise to oppose this obnoxious, anti-federal, anti-democratic, anti-secular bill. It should be withdrawn. That is the view of the people throughout India. The Muslim community is very much disturbed. They are in fear psychosis because many things have happened. They don't feel secure. Is it not a fact that Narendra Dabolkar, champion of secularism, was killed by the Hindutva forces? Is it not a fact Professor M.M. Galburgi was assassinated by the same forces? Is it not a fact that Govind Bansare, another philosopher, was killed, was murdered? Is it not a fact Gauri Langesh, the lady journalist, was murdered in Bangalore? So these things show that
continue.
they feel insecure. The Waqf Amendment Bill 2025 was passed in the Lok Sabha yesterday amidst strong criticism, dharnas and agitation. The bill proposes major changes to the Waqf Act of 1995 by introducing sweeping changes in the governance and regulation of Waqfs in India. We from the opposition parties are strongly opposed to this bill because it strikes at the very root of democracy. We vehemently oppose this anti-minority bill because it is prima facie unconstitutional, divisive and anti-minority. Anti-Muslim agenda of the bill was obvious, but what was so obvious was the bringing of the Waqf administration largely from state governments to central government. That should have been anathema to every state government. But unfortunately, this aspect has gone almost unnoticed. Until now, the Waqfs in the states and even Hindu endowments have been largely monitored and managed by the state governments. But now in case of Waqf, the proposed amendments provide for, among others, framing of rules, management of records and data, and even prescribing of ordinary forms for registration and submission of reports, etc. by the central government to near total exclusion of state governments. The bill had been referred to a joint committee of parliament for detailed deliberations. There also the opposition party members were not allowed to express their views. They were not given adequate opportunities to put questions to the witnesses who appeared before the JPC. Dissenting notes given by the members of JPC representing the opposition parties speak volume of irregularities and undemocratic manner in which the proceedings were conducted, and the report was adopted in the absence of all members from the opposition. The Waqfs in India have been legally governed in India since 1913. The Muslim Waqf Validating Act was enacted in 1913 during the British period. This act was replaced by the Musalman Waqf Act 1923, and later on in the Free India, the Waqf Act was strengthened by incorporating various provisions. This bill brings sweeping changes in the present enactment and takes away the rights of the minority communities. In the earlier law, in the case of dispute resolution of the government land, considered as Waqf property, Waqf tribunal would decide the matter. In the present bill, it has been provided for that the state government may by notification designate an officer above the rank of collector, hereinafter called the designated officer, who will decide whether a property is Waqf or government land, and the decision being final. In the principal law of Waqf Act 1995, oral recognition of Waqf was admissible for consideration of a property as Waqf. In the present bill, this provision is being removed, and properties without a valid vakrama will be treated as suspect or disputed and will remain inactive until the district collector makes final decision. No non-Muslim members were allowed in the composition of Waqf board. This bill provides for appointment of non-Muslim CEO and at least 2 non-Muslim members to the state Waqf boards. It would lead to undermining the integrity of these religious bodies, and the non-Muslim members lack comprehensive understanding of the cultural and religious practices of Islam. As highlighted by me, this is a clear violation of religious rights of Muslim community. This bill infringes upon the freedom of religion as provided under Article 25 of the Constitution and the autonomy of the Muslim community to manage their own religious affairs. This bill also provides greater powers to the government over Waqf properties, including involvement of district collector or a designated officer notified by the state government in property disputes. The right forum should be the Waqf tribunal to decide the matter. By involving district collector or the designated officer, it would lead to bureaucratic delays and executive overreach on the judiciary. Therefore, the Waqf Amendment Bill 2025 is a direct assault on the constitutional rights and the sanctity of Waqf properties, endowments dedicated to community welfare. 1 minute, sir. If this encroachment goes unchallenged, it will set a dangerous precedent, threatening religious and cultural community assets across India. This is not just about Waqf, but it is about the fundamental right to protect religious endowments, defend constitutional guarantees, and resist state overreach into community interest. I therefore oppose this bill tooth and nail with all the forces under my command. It should be rejected lock, stock and barrel.
Thank you,
Just like
Mr. Vaiko. Now, Mr. Minnambalam, we have got 5 minutes. You know, we have still left with 20.
Milky Mist. Sweeten contents to milk.
Minnambalam.com தமிழின் முதல் மொபைல் பத்திரிகை.